Here's important information from the health law firm.
Are you a physician, nurse practitioner, or health professional being offered a contract? The first thing to know is that there is no such thing as a standard employment agreement. Each contract is different. The attorneys at the health law firm are experienced in reviewing and negotiating contracts, preparing contracts, helping employers and employees enforce contracts, and litigation of healthcare contracts, including restrictive covenants. Here are a few tips to remember in negotiating a contract. Everything is negotiable. Be sure the wording of the contract represents exactly the agreement you made. If it is different or not specified, the language in the contract will govern in any future dispute. Be sure that every blank in the contract is completed and filled in before you sign. Obtain and review copies of every document referred to in the agreement. If there is a for-cause termination provision in the contract, be sure to include a cure provision. This is a provision which requires the employer to provide you written notice of any deficiency or breach and allows you a certain period of time, typically 10 to 30 days, to cure it. If you sign the agreement, be prepared to honor it and assume that every part of the contract is enforceable. Restrictive covenants, or covenants not to compete, are enforceable in Florida and many other states. Do your due diligence before agreeing and signing. Do not start working until you have a copy of the employment agreement signed by the other side. The most common problem we see when there is a physician employment dispute is that the employee does not have a copy of the contract that is dated and signed by the employer. Every set of facts and circumstances, every contract, and every case is different. Give the health law firm a call before signing your physician employment agreement. We also litigate cases in state and federal courts.
For more information, visit thehealthlawfirm.com.